Intellectual property strategies for high-tech startups. Patent, trademark, copyright, and trade secret strategies for startup ventures. Startups are very different from large organizations. They don't have the luxury of time to wait several years for a new patent to issue. Some patents take 10 years to make it through the prosecution process with the Patent Office, and the startups that filed them are often dead, dying, or sold by the time the patent issues. The legal fees for a patent assertion case are usually in the range of $2 to $5 million. Assertion of patents against infringers is not possible for startups lacking armies of lawyers and war chests of funds to finance lawsuits. When it comes to trademarks, the perspectives of startups can be different from large corporations. High-tech startups want to establish a new brand and encourage use of their trademark, not restrict it. A clean process of separation from prior employers is important for entrepreneurs founding startups. Intellectual property developed by a moonlighting employee can belong to the employer, not the entrepreneur. So when an employee has an idea to form a new startup and undertakes some of the foundation building work while moonlighting, it's important to separate the work undertaken for the employer from the personal work undertaken in furtherance of the new startup. This means using separate equipment. The employee should avoid using the employer's computers, phones, printers, and other equipment. The employee should keep a log of the time worked on personal projects. This may be necessary to prove the work was not undertaken on the employer's time or on the employer's equipment. Although many states in the United States force employment contracts rigidly, California is friendly toward employees and recognizes their right to pursue a career and earn a living. Where the moonlighting employee carefully divides his or her personal work from that of the employer, states like California will prevent the employer from claiming ownership of the patents and the intellectual property created outside of work hours by employees using their own equipment and tools. When it comes to patents and intellectual property, there are some common mistakes to be avoided by startup ventures. It can be a mistake to agree to a broad scope of licensing rights when contracting with clients and partners. It's critical to limit the scope of out-licensing agreements. Extending broad license rights to the company's intellectual property, especially providing a license with sub-license rights, can eliminate any value of the intellectual property and can act as an unintentional poison pill, killing any possibility of selling the company in future. It can also be a mistake for a small company to accuse a large competitor of patent infringement, as this could trigger a costly lawsuit. Startup companies often make the mistake of filing patents unnecessarily. If the patents are unenforceable against infringers, either due to the nature of the technology, the drafting of the claims, or the company's lack of resources to engage a team of litigators, the filing of patents may be a waste of startup finance and a waste of time. Startups may wish to file patents when they're core to the business, but there are several other strategies that a startup entrepreneur may wish to consider. Buying patents provides immediate protection. Publishing papers or articles can be used as a strategy to kill the possibility of a patent being filed by a competitor, essentially placing the invention in the public domain. A patent strategy for a startup may be to have a third-party company conduct research on the company's freedom to operate in a particular field. This involves a third party assessing the patents covering the space and allows the company to gather results without being placed on notice of the patents held by competitors. Using a third party can prevent the company becoming a willful infringer. Startups without war chests of funds wish to avoid the costs associated with assertion. This can be achieved by selling patents to a non-practicing entity with a license back to the startup. An alternative approach to selling the patents is to engage contingency lawyers to assert them. Contingency lawyers typically don't charge legal fees for their time, but they do take a substantial share of the proceeds of a successful assertion or licensing program, and they charge the costs and expenses to the company. In the coming slides, we'll cover some of these points in more detail. It's becoming increasingly popular for new companies to buy existing patents from the marketplace, rather than rely on coming up with creative new inventions and filing for new patents themselves. The Trademarks exchange provides a searchable database containing thousands of patents for sale, and it's possible for buyers to find patents matching their interests with pinpoint accuracy. Buyers are generally able to acquire issued patents at a reasonable cost. Sometimes the cost of buying an issued patent is similar to the cost of prosecuting a new one. By acquiring from the market, the time required to assemble a portfolio can be reduced from decades to a matter of months. A startup selling patents is often selling rights that the startup is unlikely to need. Patents are not much value when held by startups with insufficient funds to assert them. Selling patents may be a good alternative to raising investment funds, as it avoids dilution of the shares and the entrepreneur's loss of control that would result from a venture capital investment. The seller retains a license back. The buyer would essentially buy the rights to assert the patents against the whole world, except the startup that sold the patents. And the startup would be able to continue to sell products featuring the patented inventions as a result of the license back. Selling patents may actually help the startup strengthen its market position as a large buyer with armies of lawyers and deep pockets may be effective at asserting the patents and restricting competition. The competitors may take notice of the patents and avoid infringing when they realize the patents are held by a large organization that's capable of bringing a credible lawsuit. Small patent holders are not taken seriously by infringers. Large infringers often respond to accusations of infringement by, "Sure, sue me," or "see you in court." Large companies know that the budget for legal fees necessary to bring an infringement case to court is in the range of $2 million. So direct patent enforcement by small startup companies is often ineffective. If the patent holder is trying to force the infringer to settle out of court, an even larger war chest of funds is often required. The infringer may look to see if it can outspend and outmuscle the patent holder. If the patent holder can show it has a large budget set aside for legal fees, perhaps $10 million or more, then the infringer will be more likely to settle without taking the matter to court. Contingency lawyers often represent startup clients and take something in the region of 33 to 50% of the proceeds, depending on whether the case goes to appeal. However, the patent holder is usually required to pay the court costs and out-of-pocket fees. So contingency assertion is not cost-free for the patent holder. As we mentioned earlier, an effective method of assertion may be to sell the patents to a non-practicing entity that has the cash and the legal muscle to assert the patents and restrict competition in the marketplace. Disclosure of the invention to the public, instead of to the patent office examiners, effectively eliminates the patentability of the invention and prevents any competitors from patenting the idea in future. A description of the invention in a technical paper, a provisional patent, a magazine, article, or any document providing date-stamped evidence of the existence of the invention is sufficient to place the invention in the public domain if the inventor fails to file a patent for at least 12 months. This publication eliminates the possibility of a competitor filing a patent, then suing the startup for infringement. As it's public domain, anyone can practice the invention without fear of patent infringement. When it comes to trademarks, it's important for new startup ventures to run extensive searches to avoid selecting a name that's already in use by someone else. This can avoid a costly trademark dispute later on. Fabricated names are most easily protectable. For example, the word Kodak is fabricated, and its ownership is not really disputed. The word Apple, on the other hand, is not fabricated and has been subject to disputes with the Beatles, who had a record label called Apple, New York, who trademarked the Big Apple, and other people trying to use the word Apple as a brand. US trademarks are easily registered. Entrepreneurs can file their own at the Trademark Electronic Application System (TEAS) at the US Patent Office website. A trademark is easily filed, but it's not really critical to have the trademark registered. The trademark can be protected by merely using it and adding the TM notice to signify that the mark is intended to be protected. As for copyrights, startups may wish to take steps to avoid violating copyrights held by others. This means checking before publishing photos and other materials that have been copied from elsewhere. Copyrights attach automatically when the work is created and fixed in a tangible form. So the startup's writings and creations are copyrighted when they appear on paper, they're placed on computer disk, or somehow recorded. For example, a singer does not own the copyright to her song if she merely sings it out loud. But the copyright does attach when she makes an audio recording or writes down the musical score. If the creator is planning on litigating the copyright in court, it's advisable to file the copyright. This involves sending copies to the Copyright Office located in the US Library of Congress in Washington, D.C. As so much material has been collected by this institution, it's now the world's largest library. Filing the creations in the Copyright Office establishes evidence that could be helpful if ownership is later disputed in court. So, startups are different from large corporations in many ways. Startups don't have war chests of funds to finance the acquisition of IP. They don't have armies of litigation attorneys to represent them in court, and they're usually too small and insignificant to attract the type of lawsuits faced by large corporations. Registration and maintenance of web domains is an important activity for startups. It's inexpensive and can prove valuable. A priority for a new company wishing to establish some form of brand is to register and protect trademarks. Again, this is relatively easy and inexpensive. Copyrights attach automatically, but a startup may wish to file copyright materials at the Copyright Office when the creations are core assets for the business. This might be particularly true for startups in the business of content or media publishing. Startups should avoid knowingly infringing patents held by others. To avoid being on notice of patents and triggering a case of willful infringement, it's better to avoid even looking at patents unless the company is planning on buying them. Buying patents can offer immediate protection, whereas filing new patents can take years. Filing patents is a priority for startups when the patents are core to the business. Startups should carefully consider the assertability issues involving patents, the costs of bringing suit against an infringer, and not merely file patents because the patent attorney thinks it's a good idea. To avoid attracting lawsuits, smart entrepreneurs often fly under the radar for many years. operating in stealth mode can prevent the company becoming the target of patent litigators representing large, deep-pocketed competitors. One of the key priorities of startup companies is to hire IP lawyers that understand the constraints and challenges faced by small, fast-moving teams in high-technology sectors. Startups should avoid hiring IP lawyers that blindly proceed to file new patent applications that will be costly to prosecute, take several years to get through the examination process, and provide questionable value to the company.